Gianni Versace SPA is one of the companies founded by a designer named Gianni Versace in Italy in 1978. This company works in the fashion industry, producing clothing, accessories, cosmetics, perfume, and other products. The president of Gianni Versace is Santo Versace, while the vice president and creative director is Donatella Versace. The Versace company sells their products in Indonesia. Even some of the trademarks have been protected by Indonesia law. As time goes by, the company keeps growing. For example, in 2000, they cooperated with Sunland Group Ltd, a famous company in Australia, to open Palazzo Versace, a six-star hotel in the Gold Coast of Australia. Today, Versace is held by the Versace family that consists of Allegra Bag Versace 15%, Donatella Versace 20%, and Santo Versace 30%. Versace products are known in almost 30 countries, including in Indonesia. A few trademarks that have been listed in many countries as famous trademarks are: number 1, VERSACE; number 2, VERSACE Gianni Versace; number 3, VERSACE Classic V2; number 4, VERSACE Versace. A few trademarks have been listed in Indonesian, which are VERSACE Gianni Versace, and VERSACE Classic V2. Also, VERSACE and VERSACE Versace that was listed on 7 April 2001 and 23 January 2002. On the other hand, Jono is an Indonesian that is domiciled in Medan. He listed V2 versus trademarks that has similarities in its main words. Gianni Versace felt disturbed because the main elements of his trademarks was listed at the same time with Jono. As a result, he reported this to the Commercial Court of Central Jakarta. Legal issue. The legal issue is violation of trademark law by Sutarjo Jono. Sutarjo Jono's actions were in bad faith that aimed to free learn from the fame of Gianni Versace SPA's trademarks so he can enjoy economic profit easily from the selling of his freeloading products. Beside of this, Sutarjo Jono's listing proposal should be rejected according to elucidation of Article 4 of Law number 50 of 2001 concerning trademarks, and beside on the law that is currently filed in elucidation of Article 21 paragraph 3 Law number 20 year 2060. This explanation shows that this case is an act of freeloading of a famous trademarks that was done by a national citizen. Parties' argument. Plaintiff arguments. The plaintiff Gianni Versace SPA says that he is the real and rightful owner of the trademarks VERSACE, Versace, Versace Classic V2, and VERSACE Versace. The plaintiff says that the defendant, without permission from the plaintiff, has listed the trademarks V2 versus that has main similarities with the plaintiff's trademarks, and the defendant's trademarks is listed in the Directorate of Intellectual Property Right or HAKI. The plaintiff asks the panel of judges to cancel the listing of the trademark VERSACE versus in the Directorate of Intellectual Property Right or HAKI. Defendant's arguments. In this case, from what is printed of Jono verdicts, there was no defense or plea. When the court trial was held, Jono was not present or in absentia. Court consideration. Panel of judges of the Central Jakarta Commercial Court in Gianni Versace SPA's case opposes Sutarjo Jono in talking interpretation of fraudulent compensation according to the provision elucidation of Article 4 of Law Number 50 of 2001 concerning trademark. Statement of the panel of judges of the Commercial Court regarding fraudulent compensation is considering that elucidation of Article 4 is based on a contrary interpretation. There are two important elements to determine if there was bad faith, which are: number one, the intention to benefit the business of the lister and inflict loss on other parties. Number two, through misrepresentation of consumers or act of fraudulent compensation or plagiarizing or freeloading on other trademark claims. Besides this statement about fraudulent compensation, the panel of judges gives consideration about the act of misrepresentation of consumers as follows. Number one, misrepresentation about origin of a product. Number two, misrepresentation because of the producer. Number three, misrepresentation through sign. Number four, misrepresentation through hearing. Court decision and gives a decision that won the plaintiff's party with this statement. Number one, states that the defendant that has been called accordingly to appear did not appear. Number two, grants the plaintiff verdict wholly with verdict. Number three, states that the plaintiff is the only rightful owner of the famous trademarks versus Gianni Versace, Versace Classic Virtue, and versus Versace in the territory of Indonesia to differentiate the product of the plaintiff from other product. Number four, state that the listing of the defendant's brand Virtue versus with the number 361066 has main similarities with the famous trademarks of versus Gianni Versace, Versace Classic Virtue, and versus Versace owned by the plaintiff. Number 5 states that the defendant's action to propose a listing of the trademarks Virtue versus Versace number 361066 contains bad faith because it imitates the plaintiff's famous trademark. Number 6 states that the listed trademarks Virtue versus number 361066 of the defendants is cancelled from the General Registers of Trademarks of the Directorate General of Intellectual Property Right with all its legal consequences. Number 7 orders the clerk of court to send the copy of this decision after having permanent legal power to the Ministry of Justice and Human Rights CIKI, Directorate General of Intellectual Property Rights CIKI, Directorate of Trademarks for trademark cancellation by crossing out trademark value version versus registration number 361066 from the General Register of Trademarks and announcing it in the Official Gazette of Trademarks. Number 7. Penalize the defendants to pay this case fee in the amount of 5 million rupiah. I conclude by way of primary connecting factors are factors and conditions which show that we are facing a private international law incident. It can also mean factor and condition with the that a relation or incident is a private international incident. In this case, the primary connecting factor is the different nationalities from the parties. The plaintiff Gianni VERSACE in Italian, while the defendant Sutarjo Jono is Indonesian. Secondary connecting factors are factors and conditions that determine which state's law should be applied in an international private law incident. In this case, the secondary connecting factor is like loci delicti commissi, the law where the unlawful act is done. In this case, the applicable law is Indonesia law as a loci delicti commissi because the unlawful act is the unauthorized use of the trademark versus that has main similarities with the globally famous trademark versus VERSACE Classic V2 and versus VERSACE, which was done in the territory of Indonesia. Thank you for watching.